Hello, welcome everybody. Thank you for being here. If anybody who's still kind of walking around the end wants to sit down, we can get started. Okay, hello. My name is Midas Nouwens. I work at the Dutch Data Protection Authority, and I'm really happy to be here. We put together a panel to try and help us with one of the big challenges that we're currently facing. The motivation for this panel is that basically in the last 3-4 years, the Netherlands as a country has had to grapple a lot with algorithmic technologies. Can I see some slides? I have wonderful visualizations for you for this. The Netherlands has had to grapple a lot with algorithmic technologies. I'm sure many of you here are familiar also with the Siri case, where the Dutch public sector basically uses algorithms to decide whether certain people might be committing fraud. One of the consequences of that is that our government also collapsed over this, and then in their new coalition accord said we need to do better. So a lot of money was handed out to different organizations, one of which was the Dutch Data Protection Authority, and the task that we were given was improve the supervision you do on algorithms. Now, why we get this money, at the same time, a lot of new algorithms and algorithmic systems were deployed in society. So while we thought, oh, now we finally have the resources that we need to actually do something with this, the amount of people that were using these technologies also changed. So that's why this particular panel is called Supervising the Mass Adoption of Algorithmic Technologies, because we think that there's definitely some new challenges going from algorithms as an emerging technology to a mass market product. And that's why we put this panel together. The way that I want to structure this panel is that we'll have our different panel members give a small kind of like opening statement, and then there's a bit of space for kind of clarifying questions from the audience after each of these presentations, but I'm going to try and keep that short, so just one or two, just to kind of see like, hey, you said something I don't quite understand, can you elaborate? And then we'll go into the more like interactive discussion between the panel members and the rest of the audience. The first person I'd like to introduce for this is Michael Veale. He's an associate professor at the Faculty of Laws at University College London. He researches power and digital technologies and is especially interested in moments when there's friction between kind of the regulation, the governance that we had when that meets the actual practical reality in the real world. And so I've asked him to kind of give a slight introduction to the problem that we're facing, the way that he sees it. Michael, we have a clicker.
Thanks. Hi, everyone. I have a couple of slides just to show you, so maybe they can go on. There's the purple deck that came up very briefly a moment ago. Yeah, great. So yeah, thanks everyone for coming here today. The mass adoption of algorithmic technologies is really crucial because it replicates a lot of the dynamics we've seen before in the digital age around platforms and cloud, and we've still got a lot of unresolved difficulties in regulating those spaces, but maybe they become more tricky with some of the natures of AI systems and how they operate in practice. Now, AI, when we look at it on the ground, is structured in the form of supply chains or supply networks. And that's because instead of someone saying, hey, we've got some data, we're going to make a model, we're going to apply it, it's a very old form of machine learning. People have been worried about, say, a public sector or private sector organization just running statistical tools in their own environments in something like R or Python on their own data and then using it in their own settings. But as AI has matured, it has unsurprisingly become platform-shaped. And that means there are many actors and intermediaries in this area, all of whom determine different areas and points of the decision process. And they matter for data protection, which is what I'm going to focus on in these introductory remarks, because this is also the DPA who has asked me here, although they have some wider obligations too, coming around with different legislative instruments. In the supply chain, we see actors that replicate throughout. We see training data centers and the hardware providers, AWS, Azure, NVIDIA. These actors become important. And they also become pinch points where you might say they can allow or disallow certain kinds of training or querying. And they shape also through their systems the kind of models that can be trained or might not be trained. You have data brokers and sources. Of course, they fall under personal data legislation. And when they do that, They have labeling, which is also a form of personal data processing with people, data subjects who are producing some of that data, opinions about themselves. They're also employees in work environments. There are sources of this data, some of which might be illegal or some of which might be floating around pretty unregulated and controlled. You have developers of so-called foundation models, and what they seek to do is make powerful models that can be then built upon or tailored by other actors, or perhaps smaller models that might be tailored as well. Some of these models can be downloaded, some of them are still queried through an API and customized that way. You have firms that do further labeling, annotation on new data sources and new data sets, like Sama and Amazon, through Mechanical Turk. You have fine-tuning providers. Many of these are the same companies as earlier, but they provide services to turn larger models or smaller models into something that's more adept and suitable for some downstream purpose. You have model hosting platforms. These are traditional hosting intermediaries like GitHub and Hugging Face, and they play content moderation roles, but they may also find themselves playing data protection roles because we have, for example, the judgment in Google Spain, which confuses the idea of an intermediary with the idea of a data controller and blurs those two areas of law so that it's quite difficult to sort of navigate, mostly because I think the DGs in the Commission didn't talk to each other when they were initially drafting the e-commerce directive and the data protection directive. They're querying data centers and consumer devices. Apple and Android through Google are really key here, as well as other providers of end-user tools. They may replicate old dynamics in digital rights management about what can and what cannot run on a device, what kind of software is on a whitelist or a blacklist, an allow list or a deny list is what I want to say there. You also have users themselves as feedback providers in this space, in this supply chain. This is why tools like Bard or now Gemini and ChatGPT partially exist in order to learn how these things work in the real world in a subsidized way. And interestingly, you have firms that integrate all of the above. And so when you have a small SME, there may be a firm that says, we're an AI provider, but what they really are all of the above companies in a trench coat, and piled together, and they're also trying to combine these together in a particular way to achieve some particular functionality. And then you've got the firms themselves, the SMEs, the small organizations that are deploying them, that I think is the motivating factor behind this panel, the mass adoption of these technologies. So the number of those firms increases, but really they're a network of all of these previous actors together, and all of these might have different roles in data protection, not to talk about other frameworks now. Just three, and there are more, data protection angles to highlight here that we may get onto further later on in the discussion. There may be joint controllership throughout this chain. This is because in practice, the means and the purposes of processing are determined not just by that end deploying firm, but by some of the upstream firms, who may just give a take it or leave it option and say, well, here's what we think your problem is, and here's how we think you technically solve it. And then kind of, these small organizations are maybe forced by the market to adopt some of these tools. And we have to ask, really, where is the power? Where is the decision-making actually happened in this situation? And the data controllership is really meant to be about following the power, which is a very tricky thing to operationalize in any kind of regime. You have joint decision-making. So the Schufa case that my colleague Ruben and I had, the kind of concepts that we'd written about a few years ago, of multi-stage decision-making, where profiling happens in one actor, gets passed along, or gets augmented through many actors in the chain, and it's not really sure at what point a decision was made or not. And it's not sure at what point, if you have anomaly detection systems and these kind of other products, who is responsible for that decision-making. When you have automated decision rules in not just European, but many national data protection laws around the world, this can trigger. And you also have the idea that models can be personal data themselves when they're downloadable, and therefore SMEs or other deployers who have downloaded and used open models, they might not be open source, but they're kind of code or weights available, they may be handling personal data sets themselves and have responsibilities and obligations that are difficult to define in those situations. Lastly, just to outline a few of the challenges to set the scene here, where is the analytic capacity to understand this stuff? We find that the small companies at the ends of the chain, they often don't have the skills to carry out data protection by design or DPAs across this whole chain. I mean, that is in part because when you look at how machine learning practitioners in these companies are trained, they're getting Microsoft Cloud machine learning certificates, Google Cloud, Microsoft Azure machine learning certificates, Google Cloud certificates, Amazon AWS certificates. They're part of training pipelines which determine teach them to use certain tools, and it's unclear they really have really good supply chain knowledge of analyzing these firms, except through the way these firms want to portray themselves. AI is also sold as or hidden within other cloud services in order to maximize the use of these products and to upsell the license fees that you see from these cloud. For example, Microsoft Office is jumping in fees, and in part of that, and will probably go up further and further as more AI systems are integrated and the compute costs from that becomes more, and they're sold as an essential tool, and they're also said you'll save staffing money if you do this. But you find that AI fits more and more in, and there's less and less oversight over that. So if you ask a company, where are your algorithms, they just may not know. They may not have kept up with what the tools that they bought last week now contain. You have a controller processor cat and mouse game. Who's a controller, who's a processor of any particular thing? No one really wants to admit these responsibilities, and there's very few organizations in a good position to pin them down and make a map that can be followed up later on. And controllers, lastly, can actually be powerless, because they're battered by market forces here. They have a limited ability to negotiate up and down their chain. And interestingly, data protection has never focused, of course, on giving controllers rights, because it's not been seen to need to, because they're the powerful ones. Data subjects are not powerful. But what about when a data subject faces a powerless controller in a joint controllership arrangement? That is an interesting phenomenon we see more and more with cloud that needs to be addressed. And DPAs should be considering that when they think about the mass adoption of algorithmic technologies. So I'll leave it there and pass on to other panelists. Thanks.
Thank you. So there will be an opportunity for people to ask some clarify questions if anybody wants. So you just raise your hand and I'll pass the mic along to you. But thanks, Michael, for kind of introducing that. I think one of the things that we as the DPA have struggled with is the consequence of this is that it's hard to know what it is, how this is affecting what we're able to see, what it is that we can gather information about, right? This analytic capacity that you mentioned. But also it's hard for us to know how this affects our intervention possibilities, right? Like what is it that we can actually then try and leverage in this whole supply chain that we have some control over? Any people who want to ask a question to clarify something? No? Great. OK, then we'll go on. So I just mentioned, as a DPA, we're struggling with some of these issues. I'm now going to pass the mic on to Karen Bruinenberg. She's the program lead at the DPA for the new program that's been created on personal data, algorithms, and AI. We've recently had our first-year anniversary. And so I'd like her to kind of talk a little bit about what is it that this program is trying to do, and what are some of the things and the challenges that we've run into.
Okay, thank you, Milos, and thank you all for being here today to discuss with us these important challenges. We're here to learn today. I'm not going to tell you exactly what we're doing. I want to hear from you and from the other panelists as well. Thank you. From the other panelists as well, how we can do better. This is why we're here. I'll start with a disclaimer. I am not a GDPR expert. I joined a year ago, and while I have been learning a lot over the last year, it has been almost exclusively in Dutch, so I will be entertaining you today by trying to find the proper terms in English. What I am also not is a computer scientist. I've always been learning a lot about that as well, so please don't pin me down on the correct words here and there. What I wanted to talk to you about was the background to our program. Midas has already mentioned a bit about it. Let me take you through some of the main aspects. The program was prompted, as Midas said, by the Dutch childcare benefit scandal that has been talked about in more details in many of the panels during the past days. In its aftermath, the Dutch DPA was quick to recognize that we would need to acknowledge the specific challenges posed by algorithms processing personal data. And in order to do so, we need to critically examine our own capabilities as well when it comes to supervise algorithms, as well as have external impact, obviously by opening investigations when prompted, but also by providing guidance and consulting and working with civil society. Therefore, the program is mainly aimed at setting up the Dutch DPA for a more robust GDPR supervision of algorithms, and by bringing together experts from all over the Dutch DPA. And I think this is quite innovative in our organization, at least. So we have the risk analysts, the data scientists, the legal experts, the international advisors, And we combine our different perspectives in head-on tackling different questions and challenges that we encounter. And I can assure you that our discussions are never easy, but always very rewarding. During the past year, we have, for example, been working on multiple ongoing investigations that I will not comment upon further here, but also on contributing to, for example, our scraping guidelines, set up numerous internal workshops to further educate our colleagues within the Dutch DPA on all things related to algorithms. And we have given, for example, advice to our junior Minister for Digital Affairs on the GDPR challenges in relation to generative AI. Now to some of the challenges that we're facing that we wanted to discuss with you today. Let's dive a little bit deeper into the two things that happened while setting up the governance of this program. First of all, we thought it might be wise to establish a benchmark in the current state of play with regard to the GDPR compliance. So we, perhaps in retrospect rather naively, set up a questionnaire for a representative cross-sample of organizations in the Netherlands, and we expected the results to give us a good overview and insights that we wanted to share with you today also. But that was not quite the case. The preliminary results thus far illustrate mainly the difficulties in gaining such insights. I think this is due to two factors. The first one being that in society we have a blind spot, and I think Michael was also talking about this, for algorithms in general. What they do, how they process the personal data, how to recognize their functioning. When questioned, many entrepreneurs and public bodies answered that they were merely using a software tool developed elsewhere and were not aware of any of its functioning. The second point that we encountered stems from our position as the Dutch DPA. Obviously, DPAs have limited capacity and resources, while the whole of society is under our supervision. And we are tasked to do no less than protect fundamental rights. Therefore, we tend to aim our efforts at the biggest players, the largest infringements, the highest impact on society. But for a good grasp of the current state of play, we also wanted to acknowledge all other actors as well, the smaller enterprises, as well as the big tech companies. And we needed a large-scale sample to be questioned. So we did not use any of our formal powers to request the information, but relied on voluntary cooperation. Perhaps unsurprisingly, people were not too keen to cooperate with us by providing information about their use of technology. So we've hit a few bumps along the road, but we will continue on this road to gain good insight into the state of play in the Netherlands on the use of algorithms, because we need these insights far beyond what we see ourselves, far beyond what we're actually looking at, to see beyond what's happening. The second thing that happened, and this has been talked about in many panels as well, was the mass adoption of generative AI. And obviously, there are several risks from a GDPR perspective, and these have been discussed also. But everyone and their mother has been using generative AI in some form or the other during the past year, and many organizations were quick to adopt, in particular, chatbots and text generators, build upon the large language models, and this also ties in with some of the issues that Michael raised, to the point that we may not want to refer to generative AI anymore as an emerging technology, but rather as an entrenched technology. Well, to conclude some of the points I wanted to make today and to open up the discussion about them, given the scale and speed of artificial intelligence, do we need to explore new ways to supervise? Do we need to gain further insights? And I'm hoping to learn from you, and especially from my other panelists today, what we can gain from looking at it from different perspectives. Thank you so much.
Thank you. Again, if anybody has any clarifying questions, please raise your hand. But yeah, thanks, guidance. I think it really highlights the point that Michael was making earlier of, okay, we have all these different players that are now in the market, and that was already a tricky situation before, and now all of a sudden everybody and their mother, as you say, is using all of these different supply chains. And so then as an enforcer, as a regulator, right, you want to know what's happening. Before this, you could talk to an individual party, be like, hey, we want to know what it is that you're doing, give us your data protection impact assessment, all this kind of stuff. Now, when you're trying to do that to a 3,000 organization, you can't have those one-on-one conversations anymore. So our ability to see what's happening has really changed because of this mass adoption. Any clarifying questions, or was Karen also very clear? Great, thanks. At the end, you said we want to kind of collaborate also with different parties, right? And that's one of the things that we're also thinking about now. We've seen with the DSA, right, the way that it's trying to set up this enforcement infrastructure is giving a lot of powers to different players in society so that together you can try and regulate the technology. And so this mass adoption, I think, under the GDPR is raising that same challenge. And so this is why I've invited also two other speakers on this panel who are from different parts of society to see how is it that you've been trying to regulate from your position as a player somewhere perhaps in this supply chain, the adoption of these things and what it is that they should look like. So the first person I'd like to introduce is Buse Setin. She works at AI Forensic. She's a AI ethics and policy expert and has been working with AI Forensics, do a lot of these kind of investigative research reports, right? Be like, okay, what is it that these technologies, what is it that they're using, how do these things work, and then try and use that knowledge to influence the debate, right? So they are in a really interesting, I think, informational position that is different from the DPA.
Thank you. Okay, this one. Hi, everybody. This is Buse. Thank you for the introduction and previous panelists for setting the scene. It actually nicely ties to what I'm going to talk about. We are AI Forensics, a European non-profit. We investigate opaque and influential algorithms. I gotta go back. This is not, okay. Wow, perfect. Yes, and I want to focus on more on adversarial algorithmic auditing and how it fits into this ecosystem of broader algorithmic accountability. We talked about supply chains, we talked about recent developments and trends in the AI ecosystem, where we look at and we come in as a civil society organization that conducts data-driven investigations on platforms and algorithms, is actually where these algorithms meet people, so the customer, user, people-facing end of these systems and products. And in the past, we conducted investigations into Facebook, YouTube, TikTok, Microsoft Copilot, or Bing Chat, Amazon, and others. And here, the goal is to exert a certain reverse gaze, because platforms know so much about us, and there's an immense asymmetry of power, and how we also can use some of these fugitive tools in order to understand and analyze the behavior of algorithms that we are constantly in contact with and that we are co-creating and contributing to, actually. And for this, we have this process can be understood as a feedback loop where we develop tools to collect data from an adversarial approach. It means that we're not working with the platforms or not necessarily using platforms API in order to collect the data, but it might look like, for example, creating bots or creating scraping tools, and then we make these tools available for other researchers so that other people in the ecosystem can also use these tools and investigate, platforms. And then what we do is, after collecting the data, we analyze the data, bringing socio-technical expertise and also domain knowledge according to the research question that we're trying to look at. And we work with media or other organizations and try to present our evidence and findings to policymakers. And I'm going to talk about some concrete examples of this that we see, especially now that the DSA is in force, and we see the emergence of this feedback loop also between the civil society, regulators, and companies, and academia, and so on. So this is the first example, a recent investigation that we did, where we looked at the political ads on Meta's ad library, and basically uncovered that less than 5% of the undeclared political ads are moderated by Meta, and we can, with our actually limited means of a small nonprofit, observe a coordinated and very active network of pro-Russian propaganda, targeting more than 38 million people on Meta platforms in Germany and in France, and super actually reactive to whatever is happening politically in order to create a narrative. And our lead researcher also built a Telegram bot that we can still to this day actually see which advertisements are being still distributed on these platforms, and the platform hasn't been able to take any action, although this wasn't the first time this problem was uncovered. This was also uncovered by other civil society organizations like Check First, Reset, EU Disinfo Lab, and maybe others that I might be forgetting. But what is I find very interesting and promising to also witness is that now with the DSA and you know, this emerging ecosystem, what we do, we can provide our evidence to regulators and talk to them and present our methodologies, and this can inform regulatory action against platforms. And this news is from a little bit more than 1 week ago, and the EU Commission launched formal proceeding against Meta, including some of the findings that we presented in our report. Another example is the study that we did in collaboration with the Algorithm Watch to Microsoft Bing Chat, and its new name is Copilot, and we're going to be also looking at this chatbot for the upcoming EU elections as well. But this was also the first time we were conducting research on a chatbot that is connected to a search engine. And you know, the intersection of this very important and recent trend that we're seeing, where generative AI products are more and more integrated to other platforms and products and so on. And unsurprisingly, we found that the 30% of the time, the answers by the chatbot were fabricated, false, had nothing to do with facts, and sometimes it did so by citing authoritative sources, public sources, or media outlets, and so on and so forth. And we are, you know, 2024 is the year of elections, and we are also witnessing other I think, threats and problems that we're probably going to talk about all together. But what I want to maybe conclude with is that we think that the platforms cannot be trusted, even though, you know, they're also a part of the ecosystem to make things better. They cannot be trusted to mark their own homework. So even though we have some tools under the DSA, like, for example, Article 40, although we need to still see how it's going to work and so on, we need to be able to verify their claims, and we need to be able to also verify we need to also understand what information we need from that. That's why adversarial scrutiny is very important in order to also go beyond, you know, algorithmic accountability, beyond a compliance exercise. And for this, we need also a diverse and strong ecosystem of civil society organizations who have expertise and experience with other problems, and who can, you know, bring their domain expertise and contribute to data-driven investigations. Thank you.
Thank you. I saw a little sneak peek of the next slide where you're talking about API difficulty. No, but thanks. That was really interesting. If any, again, an opportunity for any clarifying questions, if everybody has any. If not, we will move on to our last speaker. Felix Reda is a former MEP and has been working for many, many years, not just, I think, from within the power structures, but also organizing on the ground around things like copyright, and has recently joined GitHub as one of the platforms that is in the supply chains that Michael was sketching out. And so now also is trying to influence kind of the policies that GitHub has around the uploading of different types of software tools. So I'm really interested to hear what what you're seeing as the new challenges as now GitHub is dealing with a lot more people trying to upload all kinds of stuff on there, and whether or not that's something that GitHub wants to do, or if there's any other people that don't want GitHub to do it.
Yes, thank you, Midas. I really appreciate the invitation from the Dutch DPA to talk about the different content moderation challenges that exist for a platform such as GitHub. If you're not familiar with GitHub, it's a software development platform. So people upload software for all kinds of steps in the AI value chain, from tools that are used for the creation of training data sets to analysis tools and everything in between. So at this point, GitHub hosts about 1.8 million repositories that are AI related. That's not the majority of the software that is hosted on GitHub, and also most of that are not AI models, but rather software that is used in the creation of AI, software that is used for the testing of AI. All of these kinds of steps do involve open source software and have a place on GitHub. I want to talk about the content moderation challenges that emerge for a hosting provider in this space. And I thought it would be instructive perhaps to look at how GitHub has dealt with dual-use software, so software that can be used in illegal contexts as well as legitimate contexts in the past. And what this example, I think, will show is that the different stakeholder groups represented on this panel, including academia, civil society, and industry, can play a role in solving these very difficult questions. So myself, coming from the copyright world, I'm talking about a copyright example. In 2020, GitHub received a takedown notice for a software tool called YouTube DL from the recording industry of America, who alleged that this tool, YouTube DL, was circumventing technological protection measures which would be illegal under US copyright law. Luckily, speaking in the European context, the Digital Services Act nowadays has a very similar framework for notice and takedown. So even though this particular case took place in the context of US law, the legal analysis under the DSA and under EU copyright law would be quite similar. So at the time, GitHub took down this software tool, which was met by a lot of criticism and resistance in the community, because it turns out that this software, which can be used to download videos, not just from YouTube, but from all kinds of websites, has a lot of legitimate purposes. For example, groups that help victims of online hate speech to put criminal complaints forward would have to download evidence of those of this hate speech to submit it to courts, which would require these kinds of tools. But also human rights organizations that document war crimes would scrape sites like YouTube and download videos for evidence purposes. So after YouTube DL was removed from GitHub, GitHub received a letter from a civil society organization, in this case the Electronic Frontier Foundation, which provided a more thorough analysis and was basically able to show that this particular software tool did not violate copyright law. What they were able to show in this context was that YouTube does not actually use effective technological protection measures. They do not encrypt the videos. Essentially what they were doing was they were hiding the URL, the media URL under which the video was stored, but it was possible with very simple steps to actually download those videos, and YouTube DL was essentially just automating this process. So with this additional forensic evidence and legal analysis provided by an NGO, GitHub then decided to reinstate YouTube DL. And in the context of this discussion, also in collaboration with the users of GitHub, made some changes to content moderation policies to try to strike a better balance between the different competing interests that happen in this context. And I think this is relevant also for the Digital Services Act, because the DSA requires online platforms not just to consider the interests of the person who is sending a takedown notice, but also the fundamental rights of the uploader, such as freedom of expression, right to research, and so on. So GitHub requires, in these cases of anti-circumvention claims, a lot of information to be included already in the notice. For example, you don't just send a notice saying, this software violates my copyright, but rather you have to say, what is the technological protection measure, how does it work, and then how does this software tool manage to circumvent it, to make it easier on the side of the platform to analyze these claims. GitHub also notifies the uploader when such a claim is received before taking the content down to allow them to modify the software. So if there is an infringement happening that can be easily remedied, that they have the opportunity to do that. GitHub also publishes all of the takedown notices it receives, along with statistical data and information on what happened with the complaint to generate transparency and allow academics to also analyze trends in this field, which is also something that partially now with the statements of reasons has become mandatory under the DSA. GitHub also added staff, so hired specific legal and technical expertise to the trust and safety team to be able to actually analyze the source code of software projects for which we receive these anti-circumvention claims. And perhaps also most interestingly, for these forward-looking questions about the scale, what happens if we receive lots and lots of these kinds of claims where at a certain point looking at the source code in-house might not scale anymore. So GitHub actually turned to academia. They created a 1 million developer defense fund, which is essentially enabling a law school to be contacted by developers who have received such a takedown of their project to get independent legal advice, because the Digital Millennium Copyright Act in the US, if somebody decides to challenge takedown and file a counter notice, they take on a certain legal liability. So GitHub wanted to enable people who are usually software developers and not lawyers to actually be able to file such a counter notice with confidence. And so rather than providing this legal advice in-house, which is not something that GitHub as a company would be able to do, is referring them essentially to independent legal advice and paying for that. So these, I think, are some changes that were made in 2020 that might be instructive for the upcoming content moderation issues that we might be facing in the field of AI. Because the notice and takedown system under the DSA does apply also, of course, in the context of AI, but the question of when a hosting provider has actual knowledge of an illegal activity is a lot harder to answer if we're not dealing, for example, with an instance of non-consensual intimate imagery that has been created with AI, but rather with a software that might be used for that purpose, but might also be used by researchers or by NGOs to analyze those phenomena. And so we want to make sure that this research, which relies very heavily on open source and on open access to data, is not curtailed or is not hindered by the content moderation that is, of course, also necessary in this field. So I'm happy to go into a bit more detail in the discussion on how we're trying to do that, but it's definitely an emerging issue that is, I think, important for platforms such as GitHub to enter into a dialogue with.
Thank you. Again, any clarifying questions? Yes, there's one here at the front.
Hi, Mark. Thank you very much for the GitHub. So I'm an engineer, and there is one engineering question on GitHub. We're responding to that. When we are talking about the DSA, it also asks for proactive action as well. And I understand that for a software, until analysis is not tested or you do not know what that software is going to do, it's very difficult to judge. So do you think that from GitHub society, because it's an open source and a lot of talented people all around the world, including me, we are supporting to that, is there any way to do a proactive check that because before the software is going to be launched and affecting a large part of the society, before that it's already being, let's say, not launched on the GitHub? So, for example, when we are talking about the digital platforms, we are talking about Facebook and so on, and we are talking about that Facebook should have an algorithm which decides that this is a harmful content, and Facebook should remove it before it's being published. Similarly, on GitHub, do you see also any check possible when a software is being launched, YouTube.dl, you just gave an example, a malicious software which can harm society?
I hope I caught the gist of the question. So we're trying to ensure that any decision around content moderation can be reversed. So for example, in the case of these circumvention claims, if something gets taken down after trying to contact the repository owner, even if it is taken down, we try to make sure that they can still download the contents of the repository, the issues and so on, so that if it turns out that a mistake has been made, it can be easily reinstated. I don't know if it's possible to call upon sort of the collective wisdom of the open source community in these content moderation questions. But I think there is a role to play perhaps for trusted flaggers on the side of, so when you're looking at the DSA framework, who can make these notices or who is in a good position to actually conduct the forensic analysis to find a problem with an AI model or an AI system. So I could imagine that perhaps the trusted flagger model could be helpful in this context, but then also on the side of GitHub, at the moment, every single circumvention claim that we received is checked by the legal team. So that means that somebody is actually looking at the source code, is looking at the legal framework. But the skill set required for that is a different skill set than what Veale and AI forensics have. So you would need different expertise for different kinds of analysis. So if you're trying, for example, to forensically analyze the behavior of an AI system, that would be a different task than looking at the source code of an anti-circumvention tool. So there is a question of how well does that scale and which actors, including regulators, including academia, can be enabled to participate in this content moderation ecosystem.
Thanks. Yeah, so that actually gets perfectly into my first question. So kind of to back away and to kind of summarize, the way that I'm hearing it now is we've got the situation where we already had kind of like a complicated ecosystem of supply chains who were providing algorithmic technologies. Over the past years, we've already been talking about the black boxness of those things and different methodologies to try and break them open, right? Now we're in a situation where that supply chain all of a sudden is being used by half of society, if not more, right? So it's being integrated in all kinds of different places. Then we have different groups in society trying to deal with the challenges somehow. I think now it seems we're relying on the goodwill of platforms like GitHub or NGO organizations to take on some of those challenges. Like you've developed in-house some capacities to try and kind of like deal with this scaling up, right? As a DPA, we've been given more money. That's kind of like the way that we've been, I guess, trying to scale up with this transformation as well. But I think a lot of that is a very kind of unstable ground. So I wanted to ask Michael to kind of return to you to the beginning. Do you think this point of analytic capacity that you mentioned, right now we're kind of very from the ground up trying to organize some of it. Do you think there's any kind of like legal interventions that are possible to ensure that there will be analytic capacity that will always scale with the adoption of technology, or will it always kind of like have to lag behind?
Yeah, thanks, Miras. It's I think it's one of the most important questions that we face in this area. There are so many actors in this AI supply chain ecosystem, whatever word you want to use of the day. And when you look at that chain, there is a temptation to ask, where should liability and responsibility fall? That's the natural question that gets asked in the discussions around the AI Act, in discussions around intermediary liability and the DSA and platform responsibility, and in discussions around data protection and joint controllership and the sort of cases like Fashion ID and Wirtschaftsakademie and so on that have also asked that question. It's kind of the wrong question, because if you just ask that question without thinking, what structure should the industry be so that responsibility makes sense and can actually be actioned upon, that's almost where you need to start first. Because if you start at the kind of, we see at the moment, big platform companies trying to distance themselves from the on-the-ground problems, and yet they also are similarly selling the solutions to the on-the-ground problems and saying, we framed your problem for you. You know, your problem is that you don't have enough of a text generation tool in this particular setting. You know, and here's a specific one that maybe works in your sector, but actually that's a very far step away, a very long step away from actually what is that SME or public sector organization really trying to achieve, and for which populations and for whom and so on, which is so much more contextual. And it's not to say these technologies cannot be useful in certain situations as part of a toolkit where you have other tools available as well, ideally, because they're not always the most useful thing to choose. But you need to put them in context, and that context has to be quite close to the ground, and the organization that's doing that has to be quite high capacity to work out what tool they need. When we look at the political push for the adoption of AI, the industry push for the adoption of AI, the word digitization and the fact it's equated with innovation, these are not the same things. You can digitize it badly. You can lock yourself into an inappropriate so-called solution that does more to extract value from your SME or public sector organization than it does to solve the problems you actually faced. Innovation is really about on the ground applying a technology or an application or organization to a particular problem and doing something new and interesting and making progress on that for the people who matter to your organization. Okay, we've got societal questions there as well. When we start to see that, we realize the capacity is really lopsided. It's really hard to ask these organizations at the end of the chain to take that responsibility because they are disempowered to do so. And it's really hard to ask any other supply chain actors to do that because they don't have the visibility, even though they have the resources, they have designed themselves to be quite far away. So what can we do for legally to do this? I think we have to be quite harsher on restructuring the industry. You know, you shouldn't be able to use certain kinds of tools without having certain kinds of capacity. That doesn't necessarily mean paperwork or bureaucracy. Prove it through the fact you've done lots of impact assessments. You know, if you can do a fundamental rights impact assessment, then you can actually do this. That's not really the case. That's paperwork. It's really about having people on the ground who represent the interests of your organization and your problem framing, who can really choose which technologies to do as a responsible consumer, and that there's a point that regulators can go and ask an actor that's deploying this stuff and say, okay, is it a good idea you're deploying this stuff? Have you thought about these things? Have you thought to the extent you can about the whole supply chain and about how you may be vulnerable to certain changes? That might require contractual support from, say, unfair commercial practices law. You can't bind people into contracts that disempower them, including companies. That take away their rights to know or to act or to withdraw from a contract when there are changes that are made to a machine learning model or a system. There are transparency rights you might have up and down the chain, but they have to be also maybe supported by duties to help, obligations to inform, obligations to make sure the capacity are there. I think we have these creative tools to do slight rebalancing. There's also the competition antitrust side of it, which I think will matter as well if it's applied correctly, although it's not really applied with this capacity building in mind. It's not the case. What we see now in legislation, you know, in the AI Act, there's like a new AI literacy provision, which just sort of says there should be literacy in the world. Please go forth and literate yourself. And then market surveillance authorities will regulate that, apparently. Not going to work. That provision is never going to be enforced except as some ancillary thing in some existing case or claim, and just to add to a pile of things that have gone wrong. So I think we have to think about these productive features there and be quite creative. And it's not a silver bullet, but as soon as we see the issue as being a structural one, we might be able to take action on it through lots of small changes in many parts of law and policy.
Do you think that the approach that the DSA took to also put the burden of financing the capacity building on the people that need to be regulated is a good approach?
I mean, that's for the VLOPs, right? The very large online platforms. I think it's interesting in the social media sense, but it's a bit short-sighted in the broader sense because, like, take GitHub and Hugging Face. Hugging Face is a sort of GitHub, but for machine learning models, as examples here. These are incredibly impactful platforms, but they're not actually incredibly large platforms in terms of users who are uploading to them. So GitHub is not a VLOP. But of course, something that is uploaded to GitHub, for example, the Metasploit framework, which is a popular tool on GitHub where people take vulnerabilities in Windows or Linux or something, and they're called payloads, and they put this vulnerability, this found bug that has been found, and they give a quick way for security researchers to deploy it. But of course, you can download this and not be a security researcher and attack an old Windows machine, even one that's 1 or 2 years old, and succeed in your attack. And now it's like attack as a service. These are dual-use technologies, and they're important. If someone uploads something there, regardless of the question of whether it should be there in dual use, like, it can matter. It can affect a lot of people, because even if a few people download it, it can have a big impact on the world. And the VLOP approach is a social media-focused one that says things are impacting, content is impactful because of the number of people that see the content and that use the platform. But like the GitHub Hugging Face example is that uploaded content is impactful because the number of people who are affected in a supply chain who took this content at some point and used it, and it could just be one developer who took it and then used it in some huge way. That's a different kind of impact. And it's also a kind of impact which means that revenue does not necessarily flow to GitHub or Hugging Face. It's not that they have a load of ad revenue that they get from having all these users. They are pivotally important, but they're actually only a small block in the chain. Whereas the VLOP DSA approach says, you should be responsible because you have all of these users and you're making money off all these users, and therefore you should have the pockets in order to do the moderation. Whereas looking at GitHub and Hugging Face intermediary says, yes, you're important, but you actually might not be financially reaping all the money in this chain. And so we have to ask, is that the appropriate place to put the responsibility? At least I don't think it is in a significant proportion, but there will be obligations that should justly fall across the supply chain.
Luckily, we have somebody from GitHub here who we can ask that question. Do you think it is appropriate? So you've dealt with this now, saying, okay, we get some of these challenges, right? And then we've given this to external parties to try and evaluate some of it because we don't have those skills in-house. Do you think that is a feasible approach?
I mean, first of all, GitHub doesn't receive any ad revenue. You're absolutely right. It's a completely different business model from social media companies where it's not the more users, the more revenue. And I think actually the Digital Services Act regime, the notice and takedown regime, is a good and balanced regime that enables a company like GitHub to be a responsible actor. I think the AI Act doesn't also fundamentally change that. It's still the case that the Digital Services Act applies to intermediary. The AI Act might change what is considered illegal content in the context of AI, and I think that's a framework that we can work with. Of course, the difficult question at the end of the day is when something is not illegal just from looking at it, but rather it requires extensive forensic analysis, at what point does a platform have actual knowledge of illegal activity that requires it to take it down? And I think that standard needs to be high enough so that security research does not get curtailed, so that the obligation that platforms also have under the DSA to keep legal content online in the sense of freedom of expression is also still something that we can honor. I think, well, GitHub is already taking some steps in the sense of developing the acceptable use policies, the terms and conditions to try to react to these new challenges. So just recently, we've done an update of the acceptable use policies for deepfakes, which is trying to straddle sort of a similar balance, that if a project is marketed for the purpose of creating non-consensual intimate imagery or election misinformation, that we do have a legal basis now in the acceptable use policies to take it down. But at the same time, we also had to reassure people that that doesn't mean that any tool that can be used in the analysis or in the process that has legitimate other applications would also be taken down. And I do think it will be necessary for regulators to provide some guidance in the context of the AI Act, for example, GitHub would not necessarily be able to judge whether a particular piece of software constitutes a prohibited high-risk AI system in the context of the AI Act. So I think it would be useful to have channels of communication with the market surveillance authorities in these cases to be able to actually judge these cases in the way that it's merited.
Yeah, so not only is it a capacity thing of like, okay, can we even do it? But even if you could do it, it's also the question of do you always want to? Because you might not agree with the people who are trying to challenge you on it, right?
So the European Court of Justice, I think it was the Article 17 copyright case, which I was also following pretty closely. The Advocate General, I think, made it very clear, and then also the judgment that the platforms should not be the judges of legality and illegality. They are the ones who should be enforcing once something has been found to be illegal, they should be required to take it down. But they're not the ones who should be the judge in the case. So the question is then in the AI context, who is the judge? And this, the answer might be different if we're talking about data protection law or copyright law or other legal bases. But I think maintaining this distinction between the requirement to remove illegal content, the requirement to respect the freedom of expression of users, the freedom of research on the side of the platform, but not the question of what is legal or illegal in the first place should lie with a platform like GitHub.
So then I'm wondering whether Buse, as an NGO, as AI forensics, right? You've kind of pivoted from tracking exposed to doing more like AI. I mean, it's in the name, like AI forensics. You're really trying to gather evidence. Obviously, then you're picking certain targets to focus on. How do you grapple with this question of like, should we be the ones that say that, okay, this is one that's a high profile enough one that we're going to invest some methodological construction, some infrastructure building that you have to do to target that? Do you also feel like, okay, as an NGO, this is our role to do this? Or do you also have some kind of questions around this or whether it should lie with the regulator? Yeah, very good question. How do we approach what kind of investigations to conduct? This question of concentration of power, actually, that we have been talking about, I think it's very important right now, and we are looking at this from a very contextual way. Right now, it's been more than a decade that we're like really, interacting with platforms in every areas of our lives, but we really know so little, and we have really little means to sometimes raise a problem and so on. So how we approach is we want our topic of investigation to be opaque and influential and impact very large number of people, and that's why, for example, DSA framework of designated very large online platforms and very large search engines is a good starting point for us, or it provides a certain framework, as we also are one of the stakeholders that are part of this mechanism and making it work. And I think the other part of the question was who judges. This is, the notion of systemic risk, I think many of people are also in here familiar with, is a broad notion, and I think, as far as I understand, it has been left broad on purpose so that you open the pathways of communication so that people can argue with their methodology and evidence to say this is a problem. And then, in this feedback loop between the policymaker, the industry, researcher, and civil society, hopefully you find a common ground, and by establishing certain precedents, you also establish standards and expectations. So I am looking forward to see the next steps of this process, but so far optimistic about this kind of channel of communication and providing evidence. Although again, a big role I think falls on civil society actors or other independent actors and academia who have disproportionately different means than
the platforms designated that we are talking about, and financially and capacity, legally, and so on.
Thank you. So the DPA should have more resources and more abilities to deal with this, right? But Karen, I was wondering if you could elaborate a little bit on like the things that have changed within the Dutch DPA to tackle also this kind of like mass adoption, right? There's things that have had to change from within the organization. You showed it on one of the slides, the internal and external sides of this program. What are some of the things that we had to do differently to kind of now look at this problem differently as well?
Yes, thank you. I think one of the main issues that we needed to deal with was to critically examine our own knowledge base about how technology functions, and to hire more people that can tell us, and to have the difficult discussions about how it works, how we need to examine the technology that we come across. So this is one of the things that we've mainly been investing about. To me, GDPR algorithm supervision is about to advocate for the responsible development and deployment of AI. We see organizations saying, oh, it's the computer saying no, but it's not about the computer saying no, it's about the organization hiding behind the computer that could not be bothered to put their client or citizen first, and that's what we need to have at the center of our attention. And we need to do that in an integrated approach, I think. We cannot do it from a lawyer's perspective alone or from a technical standpoint alone. We need to do it in a multidisciplinary team within the Dutch DPA as well. But what this discussion has also brought me is more of the concept of the distributed responsibility across the supply chain, risks stemming from badly designed systems and nobody being able to take proper ownership. And I was wondering if we could also perhaps have a more shared responsibility on the other side of the supply chain. So could we have perhaps more build upon the work of civil society, academia, industry in our ecosystem, just to not only engage with them, but also build upon the work that they do. And this is one of the paths I would be willing to explore, perhaps in more innovative ways in which we supervise. From a background in supranational criminal law, I'm thinking about the work of Bellingcat in the downing of MH17, the flight of MH17, that we would actually use within the public prosecutor's office to build upon in the case. And this is something I think we might explore as well, and what really triggered me in this conversation that we're having thus far. So I'm looking ahead, sorry, not answering your question.
Thanks. I heard a really soft bell in the background, which means that we're approaching the end of our time here. So I want to open up the floor for questions from the audience. I see a hand in the back there. If possible, I'd like to kind of like group the questions, but we'll just start with that one.
Hi, am I audible? Yeah, perfect. So in the context of systemic risk, do you think the conversation should move more towards a more mandatory participation of civil society? Like for instance, in the DSA, there is the provision for trusted flaggers. You can get civil society engagement, but it is more voluntary. Like it's more of a dialogue between the industry and the regulator. And of course, from a theoretical point of view, people do debate that, okay, we need civil society to be more engaged. So do you think the conversation should move, or in the sense of changing the laws, or, like I know that oversight board experiment is there. Of course, there is Facebook and there are certain other tech companies trying to do, but should that conversation move in that direction, at least looking at from civil society? Like, for instance, the commission with respect to online election reforms, they made some recommendations recently, I think in May, in which they do propose a more civil society engagement in identifying certain risk factors, but could that be a pilot in moving forward in a more participatory approach?
I mean, I have worked in civil society for a long time before I joined GitHub, and I think what is important in this field is if more civil society engagement is not just encouraged, but is expected from the legislator, that funding needs to go along with it, because otherwise you create this kind of situation where you say, well, everybody can participate, and if you haven't participated, then you have lost your chance. But there is very limited capacity in civil society in terms of funding. I think since you mentioned Bellingcat, the same is probably true for journalism. So we have to make sure that it's not just a one-way street where we say, well, civil society should be providing more expertise, more evidence, but also then enabling them to do so.
Yeah, I agree with that, and we voiced that multiple times as well. Beyond that, I wanted to say something, but kind of lost my train of thought. I think no, totally lost my train of thought. I will
Maybe we'll come back later. Any other questions? Yes, there's a hand over there.
Hi, thanks so much for the great panel. I was curious about why the Dutch DPA was asking for voluntary information instead of using their powers. Is there a rationale behind this? Thank you so much.
I think we can both answer that, Midas. We've discussed this internally, obviously, but sending out a request for information, exercising our powers would also encompass the following up if people did not respond, because we wanted to do like a real state of play, like examine the entire of society. That would be a whole lot of organizations to exercise mandate. So this is basically why we decided to do it on a voluntary basis. Thank you.
I just remembered what I was going to say. Yeah, what I was going to say that in terms of strengthening the civil society with funding, that's for sure. But also protecting them, because so far in the previous years we have seen many cases of civil society organizations or academia trying to investigate platforms like through data donation projects or like through the software and tools that they would build, and these tools would be blocked and sometimes the actors would be sued. And we need to know, where, like, basically we need safe places, or we need also support and trust that we're going to be protected, and also making sure that, let's say, we can use scraping for this kind of purposes. It should be explicitly, I think, protected. Or we have Article 40, but we need to also see how the national digital service coordinators are going to deal with these requests, to what extent we are going to be required to, argue really strongly in terms of also proportionality of the data that we want from platforms beyond what they make available as like public data, like on their API and so on. So I think beyond funding, which is super important, we also need protection and facilitation of these ways of investigation, and a broadening also of the civil society actors that regulators and industries are talking to. I think not everybody has the technical sources, but there are a lot of other civil society organizations working on digital rights, but not only, that are also looking at issues about digital rights from an intersectional perspective, for instance, that we should be able to collaborate with, combine expertise, and also find a way that the issues that people face, we basically open a pathway that we can hear them and investigate them and build capacity in that way. And I think, financial and other kinds of legal and other kinds of support is very crucial.
I think we have time for one last question, if anybody has anything. There's one over there.
Thank you, very interesting. Maybe you as a regulator can say something about working together with other regulators or other organizations, because the risks we now discuss are not only privacy risk or data protection risk, they're broader and not the systemic risk exists outside of privacy. Can you say something about that?
Well, thank you for the question. I think an excellent example of it is one of the other roles that the Dutch DPA has, and that is the coordinator for algorithmic oversight. So there's actually another branch, which I'm not part of, but some of my colleagues present here are, in which we try also to coordinate the Dutch regulators' approach towards algorithms and AI. So this is just within the Netherlands as a way of cooperation and exchanging views and knowledge about algorithms and AI, but obviously there are also European task forces and what have you not to approach this issue. I think it could be more coordinated and we could learn much more from each other, yes, definitely.
All right, thanks everybody for being here. Please give a round of applause for the panelists, and in particular, Buse, whose birthday it is today. All right, enjoy the last day of CPDP.